Friends, today we're looking at a major Supreme Court judgment that affects not just Hyderabad, but the very principles of equality in India. In November 2024, the Supreme Court struck down land allotments made to MPs, MLAs, IAS officers, judges, defense personnel, and journalists within Hyderabad's city limits. Just this week, in August 2025, review petitions against that judgment were dismissed. Let's break down what the court said, why it matters, and what constitutional values were at stake. In 2005 and 2008, the Andhra Pradesh government issued orders creating a special category for land allotment, giving housing plots at concessional basic rates to select groups like members of parliament, members of legislative assembly, civil servants, judges, defense officers, and journalists. On the face of it, this looked like a welfare scheme. But the High Court in 2010, and later the Supreme Court in 2024, found this policy to be arbitrary, unfair, and unconstitutional. The MPs, MLAs, judges, IAS, IPS officers are specially privileged over and above the perks and privileges they already enjoy. Allotment of lands at dead cheap to them arbitrarily was challenged by Good Samaritans in the High Court and Supreme Court of India. The Supreme Court has rightly questioned the arbitrary decisions made by the government. In the review petitions, senior lawyers argued that the land was allotted back in 2008, houses were already built, and families had lived there for years. They pleaded for mercy, saying they were even ready to pay market rates now. Journalists argued they were not privileged like MPs or IAS officers, because many earned modest salaries, had no pensions, and played a crucial role as the fourth pillar of democracy. They said treating them at par with powerful politicians and bureaucrats was unfair. Journalists, unlike MPs, MLAs, judges, IAS, and IPS officers, are clearly not that privileged class except enjoying access to these powerful positions for factual information. Journalists in reality, serving the society without perks and privileges by providing the public correct information, exposing the corruption in government departments, and sometimes risking their lives in their line of duty. But the Supreme Court was clear. It said creating such exclusive categories for land allotment violates Article 14 of the Constitution, which guarantees equality before law. The court described the policy as capricious, irrational, and an abuse of power. It said the state cannot use its discretion to benefit a handful of elites, while ordinary citizens, including the poor and disadvantaged, are left out. Journalists, too, cannot be treated as a special class for cheap land, the court held. The very idea of giving land at throwaway rates to privileged groups goes against the constitutional principles of equality, fairness, and fraternity. As a result, the court cancelled all such allotments. Lease deeds were declared void, but it did order that the societies and their members should get refunds, including stamp duty, registration fees, and development charges, all with interest. This judgment is a strong reminder that government policies must serve the people equally, not just the influential few. Equality before law under Article 14 is not just a slogan. It is the backbone of our democracy.